Question 336. Real estate advertising is governed by rules created by all of the following, except A. The California Advertising Board. B. The Truth in Lending Act, TILA. C. Real estate law. D. Regulations of the Real Estate Commissioner. Correct answer is A. The California Advertising Board. California Advertising Board is not directly involved in regulating real estate advertising. It focuses on general advertising standards and licensing for businesses engaged in advertising activities. Real estate advertising is subject to a combination of federal and state regulations. 1. Real estate professionals must comply with the specific advertising rules established by their state real estate commission or licensing board as real estate law or regulations of the Real Estate Commissioner. 2. Additionally, federal laws like TILA might impose disclosure requirements for certain aspects of real estate advertising, particularly when it involves financing options. Question 337. Under the California Civil Code, if a broker was showing real property to a prospective purchaser where someone had died 5 years earlier, that fact would be considered A. A material defect required to be disclosed. B. Not required to be disclosed. C. A material defect but only required to be disclosed if the death was non-accidental. D. Any of the above, at the discretion of the broker. Correct answer is B. Not required to be disclosed. Based on California Civil Code Section 1710.2, specifically addresses the disclosure of deaths on real property. It states that a seller or their agent is not required to disclose the fact that an occupant of the property died upon the premises or the manner of death where the death occurred more than 3 years prior to the date the prospective buyer offers to purchase, lease, or rent the property. In this scenario, the death occurred 5 years earlier, which is beyond the 3-year disclosure period specified in the California Civil Code. Question 338. The Uniform Commercial Code, UCC, requires a notice to creditors of a business that is making a bulk sale must be published at least before the sale is transacted. A. 1 day. B. 12 days. C. 1 month. D. 3 months. Correct answer is B. 12 days. Under the California Uniform Commercial Code, specifically Division 6 concerning bulk sales, the notice to creditors of a business making a bulk sale must be 1. Published at least 12 business days before the date on which the bulk sale is to occur. 2. Given to the county tax assessor in each county in which the property to be sold is located at least 12 business days before the date of the bulk sale. 3. Delivered or sent by registered or certified mail to all known creditors of the seller at least 12 business days before the date of the bulk sale. Therefore, the publication requirement aligns with the other notification requirements at a minimum of 12 business days before the sale. Question 339. In an option agreement, consideration refers to the A. Appraisal of the optioned property. B. Optionee's promise to try to purchase the optioned property. C. Something of value conveyed by the optionee to the optioner for the right to purchase the optioned property. D. Past services rendered by the optionee to the optioner. Correct answer is C. Something of value conveyed by the optionee to the optioner for the right to purchase the optioned property. In contract law, consideration is something of value exchanged between the parties that creates a binding agreement. It can be a promise, an act, or forbearance, refraining from doing something. An option agreement grants the potential buyer, optionee, the exclusive right, but not the requirement, to buy a property from the seller, optioner. This right is valid for a specific timeframe and at a previously agreed upon price. The consideration in an option agreement is the payment or something of value that the optionee gives to the optioner in exchange for this exclusive right to buy. This payment is typically non-refundable, even if the optionee decides not to exercise their right to purchase the property. Question 340. Alleged violations of the real estate law are prosecuted by the A. FBI, B. California Secretary of State, C. Local district attorneys, D. Both A and B. Correct answer is C. Local district attorneys. The FBI primarily investigates federal crimes that cross state lines or involve federal agencies. While real estate fraud can sometimes involve federal offenses, e.g., wire fraud, mail fraud, the routine prosecution of violations of the California real estate law falls under state jurisdiction. The Secretary of State's office in California primarily deals with corporate filings, elections, and notaries public. They do not typically prosecute violations of the real estate law. The California Department of Real Estate, DRE, now known as the Bureau of Real Estate, CalBRE, investigates alleged violations of the real estate law. If their investigation uncovers evidence of criminal activity, they typically refer the case to the local district attorney's office in the county where the violation occurred. The district attorney then has the authority to prosecute these criminal violations in state court. Question 341. A will that is dated, written, and signed in the testator's own handwriting is A. A holographic will, B. Non-binding, C. A parole will, D. Admissible if a majority of the decedent's immediate family agrees. Correct answer is A. A holographic will. A parole will is an oral will. These are generally not valid for the transfer of real property and have very limited applicability to personal property in specific circumstances. The admissibility of a valid will, including a holographic will, to probate depends on meeting legal requirements, not on the agreement of the decedent's family members. While family consent can sometimes play a role in settling estate disputes, it doesn't determine the initial validity of a properly executed will. A holographic will is a will that is entirely handwritten by the testator, the person making the will, dated by the testator, and signed by the testator. In California, and many other jurisdictions, holographic wills are recognized as valid even if they are not witnessed, provided they meet specific requirements. Question 342. The following are base and meridian lines in California, except A. Humboldt, B. Mount Shasta, C. Mount Diablo, D. San Bernardino. Correct answer is B. Mount Shasta. The U.S. Public Land Survey System, PLSS, also known as the Rectangular Survey System, is a method for dividing land into grid-shaped townships and sections for sale and settlement. The PLSS was established in 1785 by the Second Continental Congress to survey land ceded to the United States by the Treaty of Paris in 1783. Thomas Jefferson first proposed the system as a way to divide up the original public domain lands. Question 343. Which loans are most similar to each other? A. Interim loan, takeout loan, B. Interim loan, construction loan, C. Construction loan, standby loan, D. None of the above loans are similar. Correct answer is B. Interim loan, construction loan. Interim loans are often used for projects with multiple phases, where funding is dispersed in stages as construction progresses and milestones are met. Construction loans typically cover the entire project cost up front and are paid back with interest over a set term after construction is complete. They share these similarities: used for financing construction, short-term financing, involve progress monitoring or milestones. A takeout loan is a permanent financing option used to repay a shorter-term loan, like a construction loan. They are not directly involved in funding construction itself. A standby loan is a loan commitment that guarantees financing if certain conditions are met. It's not directly used for construction funding but provides a safety net for the borrower. Question 344. Agency relationships, like a listing, may be terminated in all of the following ways, except A. If the property with which the agency is concerned is destroyed, B. Mutual termination agreed upon by both the seller and agent, C. Resignation of the agency by the broker, D. Revocation by the principal if the agent owns an interest in the agency's subject. Correct answer is D. Revocation by the principal if the agent owns an interest in the agency's subject. A. If the property with which the agency is concerned is destroyed, this would terminate the agency by operation of law due to impossibility of performance. The subject matter of the agency, the property sale, no longer exists in its original form. B. Mutual termination agreed upon by both the seller and agent. An agency relationship is based on mutual consent, and therefore, both parties can agree to terminate it at any time. C. Resignation of the agency by the broker. An agent generally has the power to renounce or resign from the agency relationship, although they may be liable for damages if the termination breaches the agency agreement. D. Revocation by the principal if the agent owns an interest in the agency's subject. While a principal generally has the power to revoke an agency, even if it breaches the agreement, potentially leading to liability for damages. This power is limited when the agent has an agency coupled with an interest. An agency coupled with an interest exists when the agent has a property interest in the subject matter of the agency. In such cases, the principal typically cannot unilaterally revoke the agency. For example, if a broker advanced funds to maintain the property and the listing agreement stipulated repayment from the sale proceeds, the broker has an interest, and the seller's ability to revoke might be restricted. Therefore, the principal's ability to revoke the agency is restricted if the agent owns an interest in the subject of the agency. Question 345. An accidental death occurred on a property. 4 years later, is there a requirement for the broker showing the property to a potential buyer to disclose the death? A. Yes. B. Yes, but only if the buyer specifically asks about it. C. No, such disclosure might hurt the chances of making a sale. D. No, it is not a material fact. Correct answer is B. Yes, but only if the buyer specifically asks about it. California law, Civil Code Section 1710.2, relieves sellers and their agents of the proactive duty to disclose a death on a property if it occurred more than 3 years before the buyer's offer. However, this doesn't mean the information can be withheld if the buyer directly inquires about it. In such a case, the agent has a duty to answer truthfully and honestly. Many real estate professionals and brokerage firms, particularly in California, often utilize supplemental disclosure forms that may include questions about deaths on the property, regardless of the time frame. This proactive approach aims to ensure transparency and avoid potential future legal issues, even if not strictly mandated by the 3-year rule unless a direct inquiry is made.